24 CR 777. That's good luck. In Haiti, I think. Is called here in this case, you are Christian Armani Simeon, correct? Here with Mr. West, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed to summary?
Yes, Your Honor, please.
In summary, this indictment alleges a most serious charge that on or about March 5th, 2024 in Jefferson County, Texas, you committed the first degree felony of aggravated robbery with the use or exhibition of a deadly weapon, namely a firearm. Do you understand what you're charged with here?
Sure.
If convicted of a first degree felony, you face a term of life in prison or any term of years of not more than 99 years in prison or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached. In your case, you would be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length. There will be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, sir.
Going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
States Exhibit 1. Part of the record for all purposes. Pre-sentence report is waived.
Yes, please.
I'm going to follow this agreement. Stand by. Looking at this probable cause affidavit. So, okay. So 2 people, this defendant and Javon Sims go to get a haircut from somebody. And then according to this probable cause affidavit, Sims displays a rifle, demands a firearm that is owned by the person who's going to be given the haircut. During this incident, the defendant is in the bedroom attempting to steal the victim's gaming system. And at this point, the victim is in fear of his life, presents pulls a firearm and shoots the Sims, and then both subjects escape. Sims gives a confession that he did commit the act of aggravated robbery, and then Simeon here was with him. Okay, all right. That's all they said. There's not a lot of depth here,
Right.
you know.
That's why deferred was offered in this case.
I understand.
Yeah.
But in conditions of probation, what this court normally does is I put people in jail for up to 106 months, which I can do as a condition of probation when there's an aggravated crime that's being committed, especially when you're, this is all too often a problem. And that's why this court does what it does. And I say, you commit a violent crime, you're going to jail. You just go to jail. You made it, you've signed your contract. That's what happens. You're held accountable, and deferred or unadjudicated probation includes confinement up to 6 months. What's the state say on it?
Judge, if the court finds that that's appropriate, an appropriate condition.
Whenever an aggravated robbery is committed,
I would argue against it for
Why?
well, the sense that he's not the one that had the gun. If he had the gun, then I
Did
would
he
not
commit,
argue it at all.
did he commit aggravated robbery as a party?
Just by law of parties because he was there with
It's
it.
just by law parties, but I mean,
I know.
the legislature enacted that for good reason.
And that's why
They just don't include people who are in the area code.
I know.
He had an affirmative act that he took part in, knowing that it was going to, that whether he held the gun to the guy's head, whoever's holding it to somebody's head,
Right.
they and everybody helping that person are held accountable.
I understand that. My other argument in this case is Mr. Simeon has been on bond this entire time. He has never missed court. He's never had a
No,
problem.
but that all did not prevent him from committing a crime. He's not going to be punished for being good on bond.
I know, but I'm saying there's other factors I think the court needs to consider that this is a little different than a lot of times what we see. And I understand the court does do this in a lot of these cases. And like I said, if he had the gun or actually the primary, I don't want to use the term primary, but the person had the gun, I wouldn't even be asking anything of the court. I know what the court would do. But I think it's a different situation. He was there. This whole thing went down. I don't think he ever knew this was going to happen. At least I've talked to him several times. He had no idea this was happening or going to happen. It wasn't intentional or didn't go there with that intent. But it did happen. He was part of it.
How was he part of it?
Well,
If he didn't have intent.
Well,
You're about to talk out of a deal here.
Well,
You know that.
I know.
He either committed the crime or didn't. And he had to have a culpable mental state to go along with the law of parties. He helped him or not. What did we do? If you didn't help him, you didn't. We're going to trial. We'll let a jury try it. Hey, you've said enough. You know what you just did. You've walked this thing out of the.
Let me finish. I haven't finished the rest of it, Your Honor.
Yeah.
I didn't say he didn't go there with the intent to armed robbery, the intent to steal the item, which actually did happen. We know that. Okay, that's what we talked about. But then the gun got pulled. I don't think he knew that the gun was going to be pulled, but he still went along with it and still continued with the process.
How did he do that? How did he get involved in the law of parties for aggravated robbery?
Because he was the primary person. Mr. Sims was using the gun to steal.
He had to
apparently the gun. Okay. Right. Okay.
But what that said,
he was stealing out of the other room, stealing the gaming system. It was Xbox, right? Or was it PlayStation? Right. The gaming system, and then it all evolved from there, Your Honor. Then
let's read the law of parties so you know what you've done here.
And if when the gun would pull, if he would walked away or stopped, then he would be out of that. But when he continued on with what he was doing, that includes him with law of parties.
Mere presence of the defendant at the scene isn't enough, but it is circumstance combined with other facts that may show that he was a participant. He is criminally responsible for an offense committed by the conduct of another if, acting with the kind of culpability required, he causes or aids a person to engage in conduct, acting with intent to promote or assist the commission of the offense. He solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. Okay, culpability is all part of those.
Yes, he was
But he said he didn't do any. He wasn't there to do anything.
I think they were there to steal stuff. I don't think he initially knew that there was a gun involved, but he didn't.
He had to solicit, encourage, direct, aid, or attempt to aid the other person to commit the crime of aggravated robbery. What did he do to help commit the crime of aggravated robbery?
While the guy had a gun out, he was taking items. Therefore, he becomes part of it. I'm just saying that I don't think his intent when they got there was to use a gun, and they were going there to steal stuff. Sure. But when the gun came out, he didn't abandon it, which would at that point.
What did he do other than just be present? What is it that what affirmative acts did he take?
With the other guy
part of the robbery?
Yeah, he was taking items. That's part of a robbery. When you're taking items that don't belong to you.
Could you go over that again? I guess I was slow in school. Is that right?
He was
committing. I'm just kidding you.
I know he was taking items.
He's got to have a culpable. He's got to have a bad mindset.
Taking stuff is a bad state of mind. Stealing stuff from people is a bad state of mind. And then when the gun came out, he didn't.
Did you know he was going to rob the guy or not? Surprise.
I agree with my outfit because he came there with me.
That's
He was
the
my
only
friend.
reason.
He was my friend, so he came for me, so I'll take the blame for that. Because if I would never brought the weed, nothing would have happened. Since I brought the weed, it's my fault.
It would, okay. You're pleading guilty because you think you were a friend of his, because of your friendship.
Oh, no, sir.
Yeah, that's not the test. You have to have done some bad things as part of this crime of aggravated robbery.
Yes, sir.
What did you do?
They claimed that I grabbed things.
No, well, I don't care what they
Yeah.
claimed.
Well,
What
yeah.
did you do that was part of the robbery, sir?
I didn't. I was in the bathroom. I went to go grab a lighter. Then that happened. Two people didn't like the way each other was looking. Then that happened. I heard a gunshot out the house. I think I took it. So
Anything else? All right, we'll set it for trial.
Okay.
That's all we can do. He doesn't, the record didn't support it. He's not admitting guilt or culpability here. It'll be set for trial. We'll let a jury decide your fate. Okay. And they don't give probation. But anything else?
sure.
That is all. No, it's set for trial. You talked yourself out of, you're not responsible. You're not guilty. And that's what you made it clear. We can't accept a guilty plea when it's not guilt. You didn't do anything wrong according to you, except steal some stuff in the other room. It's the other guy's fault. So we'll let a jury decide. We'll set it for trial. All right. That is all. Thank you. When are we going to have a hearing on this motion? Can we do it next week?
Yeah, it's all administrative, Your Honor. We
Are
can
you
do
be
this.
ready next week?
Yeah, sure. We're not in trial on that other case.
We'll try. We'll see what we can do.
Well, hang on. I say that, but I need to get some records from Spindletop, but I can subpoena them to appear in person, so that shouldn't be an issue.
Castillo, Mr. Joseph. Come forward here on this 19-31708. There's a motion to revoke probation that's been filed, which alleges that you have been placed on deferred or unadjudicated probation for the state jail felony of illegal possession of a controlled substance. That was in 2019. What's happened? Was he an absconder?
He he violated and was taken out of the safety.
He relapsed, Ron.
We sent him to safety and then he came back, he relapsed, we sent him to safety.
No, hold on.
relapsed.
He was on probation for 5 years
You
since
extended,
2019. Oh, it's not showing that it was extended.
you extended it on June 10th, 2020.
Okay, because the way this reads, he completed probation 2 years ago, actually, yeah, 2 years ago, right at 2 years ago, according to this, because it doesn't show anything about anything past 5 years deferred, which would have ended in 24. Is that right? Your probation was extended for how long?
2 years, Judge.
All right. So it alleges you failed to avoid disreputable people by being around those actively smoking marijuana. You provided urine samples that showed the presence of drugs. Urine samples showed the presence of alcohol. Urine sample, cocaine and tetrahydrocannabinol. Failed to submit to alcohol and or drug screening. Failed to pay court-assessed fees as directed. Failed to enter and successfully complete the substance abuse felony punishment facility back in July of 24. There's 8 different violations. Only takes one or more for the court to find that you violated the probation. You could then be found guilty and sentenced up to 2 years in the state jail. Do you understand what you're facing?
That's right.
Okay, all right. So what are we going to do?
Judge, with you just asked when we would be ready. Again, I do need to make sure that we have Spindletop available to discuss mental health records. Aside from that, I believe we were set today on a bond request. It's unadjudicated probation. I understand there are concerns if the court did proceed with instituting a bond. The concern from a perspective of the mental health caseload is whether or not his conditions are being adequately addressed while in custody. And so I think that's gonna have to be better explored. Obviously, there is no,
Why don't you do that? You're gonna represent him. I'm not gonna be able to figure that out. Isn't that your concern? Because I'm gonna listen to whatever you have to say. What do you have to say about it?
about
What do you want
mental
me to
health
do?
concerns. Or I'm asking for a bond, Judge. I thought I had made that pretty clear.
No, I'm talking about his mental health concerns. What is it you want me to do? What
As,
do we need to do?
as far as his mental health concerns right now, I don't need the court to order anything.
Okay. All right. What are you asking for here? Exactly.
In
Just a
terms,
bond of any amount.
in terms of an amount, what am I asking for?
State, what do you have?
Judge, I'm concerned with all these positive drug tests and the fact that safety doesn't look like it worked. So I would ask the court to, whatever bond you set, to take that into account, specifically for his own safety. As far as I'm concerned, when he's out there, he's using drugs. I can be ready quickly. I would rather it stay at the state that it's in now. These are administrative violations. The state's ready to have a hearing.
I know typically when there's a bond issue on a motion to revoke deferred, it's usually anywhere from 1/2 to twice the original bond.
Never look at that. We look at what's new,
I think
probation
just
and what he's done, because those are all new. That has nothing to do with the original bond. It's how he performs. That's new information that is part of the calculation. Oh, where you got that?
I wrote down in my notes that this young man is lucky to be alive. Just looking at all the drugs that he's been using there, I don't want to take the chance that he's not going to be here for a hearing.
It's probation.
I've worked with Mr. Castillo for some years. I was his QMHP at Spindletop. He's been on the mental health caseload several times. Since being his probation officer, he came back from St. Pete. He relapsed less than a month later, went back to St. Pete recently, 30 days, and he used while he was there. And since he's been home, he's tested positive for barbiturates, THC, cocaine. When he's not taking his medicine like he's supposed to. And we've talked about that. We've discussed that. He's diagnosed with schizophrenia. And he knows that when he doesn't take his medicine, he starts drug seeking. The last time he
Are you
tested.
getting your medicines? Okay.
In county, I'm getting it about 2/3 of the time,
Really?
and they're
What's the,
not giving me the afternoon dose.
sir?
I'm not getting the noon dose. In about 30 minutes, I'm not getting.
Do they know about it?
Yeah. Yes, sir. Yes, Your Honor.
Did you tell your attorney?
We were just able to talk for the first time since I've been locked up a few minutes ago.
Yeah.
Things have been fairly rushed.
I'm sorry, you've been locked up a few minutes ago?
I was only able to speak to him since I've been locked up a few minutes ago.
How long have you been locked up?
About 2 months, almost 2 months.
He's not seen you in 2 months?
Yes, Your Honor.
What about that? What are you figuring out that you need? I mean, does he need some medicine?
Well, I know that he was previously on Cogentin. And
What about right now? What do you know about him? You hadn't seen him in 2 months, but what do you know?
as far as what he's presently taking at the jail, I don't know.
Can you figure out? So we know he's getting medicine
Yeah,
like he should,
Thorazine, Buspar, and benzotropin.
sir?
Thorazine, Buspar, Buspirone, and benzotropin.
When you're getting the medicine, do you feel okay?
Normally, yes.
Uh, Uh, anything else, Dan? Then his bond is $20,000. If you post your bond, you need to have a drug patch as a condition of bond so that we know if you're using any drugs. And that it has to be done as a condition. Then you have to be taking all your medicine as a condition.
That's right.
You know, the probation officer tells me that at least one of those positive tests was on a drug patch when he was on probation.
Failure is not an option.
That's right.
I would do it. But anyway, I'm setting this for a hearing next week.
That's right.
All right. Is that? That may have made. Yes. How about? Yeah, that's it. I'm not sure.
I think she's on
That's
this
just
today.
important.
I think she's on this today on probation.
It's just this. I don't think it's gonna file in this court, so, but it's.
No, you've been on probation.
All right,
June 4th.
24 CR 577 is called your Tara Hoffman.
Speak up.
There's a motion to revoke unadjudicated probation here, that's been filed against you. You're on a Class A misdemeanor assault as of June 4th, 2025. You were charged here originally with the second degree felony of assault on a peace officer, and then it was reduced to a Class A misdemeanor assault, and that was in June of this year. And there's a DWI. This states you committed driving while intoxicated on October 21st. So that was about 3 or 4 months later. And then also you failed to never become intoxicated by being under an influence of some intoxicating substance on that date, which is a different condition of probation that is alleged you violated. Failed to provide verification of performing community service hours as required, and failing to abstain from the use of any and all intoxicating substances. Those are all different conditions of probation that it is alleged you committed, and it looks like from that event in October. So we're going to have a motion hearing on this as soon as possible. I'd like this set for next week if possible.
You can be that, we'll have results back here.
Okay.
We just want a bond.
I want a hearing as soon as possible. When can we get those back, do you think?
I'll need to, I'll have to contact the agency. to see what's
Did
going
they
on.
do one? I mean, they took, I guess,
Did they do a blood test?
something from them.
Evidently there was a blood
But,
test.
Okay, what are you asking for?
A bond.
Okay, what's state?
Blood was collected, to go back to answer
Okay.
that question.
If we can get that hastened, that'd be nice. Because I don't want, the motions have been,
As of right now, I cannot speak as to timing because I didn't know that this is the direction it was headed. I'll have to contact the agency and find out, Your Honor, where we're at with that. As far as that goes, we can move forward with a hearing if Your Honor wants to do that. I can get the law enforcement agency here. We can work without the case being filed.
I think a lot of it has to do with the results, huh?
It would.
Okay.
Whether
But
they,
according to the PC, there's field sobriety tests that were done, and the officer can talk about that. I can prove intoxication without the blood test.
I'd like a blood test. Yeah,
Yes, sir.
Thanks.
Yes, sir.
So, what about the bond? He's just saying a bond, and he's not even descriptive. What are you kind of
Well,
bond
it's a
are you talking
misdemeanor.
about? I know it is. What are you talking about?
It's deferred. She's entitled to a bond, Your Honor.
Okay, you're going, I'm going to grant a bond of $5,000 in this case, but you cannot operate a motor vehicle, period. on my watch until we get this resolved. Do you understand?
Yes, sir.
You're going to have some other way of getting around. And then also you what is it that we want to do for the alcohol? I want to.
Probation officer is suggesting the drop program, Judge.
Oh, that's, she was to install the inner one.
No, I want something else. What else
Interlock
prevent
device.
from alcohol?
Well, sure,
Seems to be a problem.
he's not driving. It'd have to be scram. If he wanted to do something. She is employed, were you employed,
Excel group.
doing
Electrical,
electrician,
yes, sir.
electrician work? What?
Okay, there was vodka in the center console. Okay. So, we need to get something that, what device?
Scram device.
The scram device,
All right. And where does she acquire that?
recover, I believe they have one in Liberty. That's the closest.
Okay, and that, how does that work?
It's on around her ankle and it monitors it through her slash.
Okay, that will be ordered as a condition. We're gonna fix this mess.
All right, just when you get it out, you'll have to get the scram installed, just get with the
And
bond.
Liberty.
I don't know where you go.
It's fine. Goes on your copy on
Yes.
Thursday.
You'll see that. Just not drive.
Would maybe I could come tomorrow. Tomorrow.
You get back to work.
Mhm. It'd be difficult without being able to drive, but try.
That's Uber. We can see.
You can't operate a motor vehicle until we can get this disposed of.
That's just
Sir.
talks with it still.
It was set this for a motion to revoke hearing as soon as possible. I have Reginald Allison.
That's also a volunteer question.
So who's here for Mr. Boyd?
Same for the judge.
You need probation? Or do y'all want to go without one? How's he doing on probation?
This is Mr. Allison.
Yes, Chair.
Reginald?
Other than this new charge that he picked up back in September, he's current on fees and reports as directed, Your Honor. And he still has incomplete CSR hours and that's positive THC and opiates.
We're asking for reasonable bonds, Your Honor.
That represent you before?
I'm not sure. That's Mr. Michael Laird, if he ever represented you.
I think it was like more like your dad or.
That's part of my dad.
Yeah. I think so. I saw my name on it, but yeah. It's his dad.
What are y'all doing on this case, by the way?
Which case?
This underlying.
Is it Chris?
This is Mr. Boyd,
Oh,
but this is not,
I see.
it's not been filed with our office. It's not.
That's in
not our office,
Nacogdoches
yeah.
County.
So
Did,
if we do anything, we're gonna need at least a couple of weeks if we have to do a hearing to get these people here,
what's,
make arrangements.
hold on. What's? Okay, what are you asking for?
A reasonable bond, man.
What state say?
He's on deferred, right?
Yes.
Yes. Nice.
Since he's got a new offense, would ask it if there is a bond that he'd be under house arrest with a GPS monitor and that's our request, Judge.
If he is under house arrest, we'd like an exception for employment purposes.
No way.
He has to make a living.
Well, he's selling drugs. He's moving drugs. That's what he got caught with. In Nacogdoches, he's, how much is this here? Pounds. 2 pounds of marijuana in the vehicle. He's in Nacogdoches. Isn't he supposed to stay in Jefferson County? He's in Nacogdoches and, yeah, okay. And he's, and this is on, at what time? Does he have a curfew?
Yes, Your Honor, it's 10 p.m.
10 p.m. So he's in Nacogdoches at 10:14 with a bunch of marijuana.
Where's alleged to be?
Anything else allegedly?
That he's alleged that he violated his probation, but we'd like a bond pending a disposition.
$50,000 is your bond. You'll be at home arrest. You cannot leave home if you post your bond. You have to have a GPS device on you at all times. You cannot leave the house for any purpose whatsoever.
Well,
I can't trust you.
other than to report to probation or from his attorney.
Yeah.
Other than that, you can't leave.
This hearing, soon as possible. When can we?
Judge, let's do, since it's, I don't know what the situation is and that.
We're fast tracking motion to revoke probation.
We do 3 or 4 weeks. That way we make sure we have.
3 weeks. Let's set it for 3 weeks on a hearing. That is all.
Has it gone through the appellate process yet?
Kobe and Dorsey, that's you?
Okay.
Come on, it's 25 CR 1055. There's a third degree felony of evading arrest or detention with a motor vehicle. What are we doing on that? It's an announcement. It's yours.
You said it for
Set for trial. Next is Rame Provost. You don't have a deal on this?
No.
Then there aren't, you don't have a deal. We're gonna just let it roll on the probation hearing, okay?
We were wanting a bond.
There won't be I don't accept deals anymore, except right now, okay? There's a motion to revoke unadjudicated probation. That was filed August 25th. You were charged with aggravated assault, 10 years deferred probation. You Ream Provost,
Yes, sir.
Failing to provide verification of performing community service hours, failing to provide verification of participating in GED, failing to pay for assessed fees, failing to have a GPS monitoring system installed.
Judge, I filed an amended motion last week. I don't know if you're looking at that.
Didn't get in there.
I saw it was accepted. I
Failed to surrender his Texas driver's license at the time of the judicial review.
That's the GED part.
I don't have, do you have a copy of it with you?
I'm trying to type one out right now.
He entered the program. He enrolled in Illinois. I guess he didn't get the GED, but they let him enroll in college. Yeah. You got that, okay.
Okay, come over soon. All right, yeah, Jimmy, we don't have the proposed boards yet.
There's no proposed order. There's, because he was already out on that. I just did the motion.
You got a thing showing.
Okay.
There was a mistake, Judge. The original motion didn't include one of the administrative hearings. So everything that was added was from the additional administrative hearing.
Among these others, it states he failed to enroll in complete online drug education course in violation of a hearing held in May 14th. Failed to never commit an offense by being public intoxicated, by having committing the offense of public intoxication on or about April 14th in Port Arthur, Texas. Failed to never use or possess a drug by testing positive for marijuana on April 17th. Failed to not become intoxicated under the influence by being arrested for public intoxication on April 17th. The problem I have is this. I don't know what I'm supposed to do, if I'm supposed to release him home confinement and he's failing to have a GPS monitoring system. There's no way we can. I mean, there's no way we can figure out where he is. Right.
I believe if Mr. Prevost could address that, how will the court know where you are if the problem on GPS system?
I want a GPS. That's what we normally have. And what was his problem about having it from probation?
He said he couldn't afford it at the time, and as of today, he's built up enough to device installed.
How long has it been?
He's been in jail, what, today makes 14 days? Yes, sir. And he has 2 positive drug screens. His drug of choice, judge, is marijuana. And what upset my supervisor on a day of a hearing, he presented us with a compassionate use registry where he could legally use marijuana. And the doctor's excuse was he was diagnosed with PTSD. But I never received any type of documentation from Mr. Prevost that he had any type of mental health issue.
Okay. You have to have a foundation to support something like that. But I'm more concerned about him ambling about. I was not knowing where he is when he didn't have a GPS device. When can we have a motion on this hearing?
It's hearing on this motion.
Yeah, a hearing.
I can do this relatively quickly as well, Judge.
Can you do it in 2 weeks?
Yes, sir.
All right.
Go ahead and turn it to Mr. Hampson.
All right, I'll hold this in consideration. We're going to have this hearing as soon as we can.
So there's no bond?
No. And if he's unable to have a GPS device, there's no way we can really keep an eye on him. Gary Boudreaux is next. Gary Boudreaux.